The senator from Ohio.
Mr. Chief Justice, I send a question to the desk on behalf of myself, Senators Toomey, Cornyn, Crapo, Ernst, and Moran.
Thank you. The question from Senator Portman and the other senators is for the counsel for the president. I have been surprised to hear the House managers repeatedly invoke constitutional law professor Jonathan Turley to support their position, including playing a part of a video of him. Isn't it true that Professor Turley opposed this impeachment in the House and has also said that abuse of power is exceedingly difficult to prove alone without any accompanying criminal allegation? Abuse of power has never been the sole basis for a presidential impeachment and was not proven in this case.
Mr. Chief Justice, Senators, thank you for that question. And that is exactly correct. Professor Turley was very critical of the entire process in the House and of the charges that the House Democrats were considering here, both the abuse of power charge and the obstruction charge. And he explained that this was a rushed process that had not adequately pursued an investigation, that, as the senators point out in the question, abuse of power is an exceedingly difficult theory to use to impeach a president, and it has never been used without alleging violations of the law. And I think that in the discussions we've had over the past week and a half, we've pointed that out multiple times. Every presidential impeachment in our history, including even the Nixon impeachment proceedings, which didn't actually lead to an impeachment, have used charges that include specific violations of the law and the criminal law. Andrew Johnson was charged mostly in counts that involved violation of the Tenure of Office Act, which the Congress had specifically made punishable by fine and imprisonment, and even wrote into the statute that violation would constitute either a high crime or a high misdemeanor, but one of those terms to make it clear that it was going to be used to trigger an impeachment. In the proceedings, in the Nixon impeachment inquiry, each of the articles of impeachment there, except for the obstruction of Congress charge, was sort of treated separately on the obstruction theory, included specific violations of law. There were specific violations alleged in the second article of impeachment, which is often sort of referred to loosely as the abuse of power article. It wasn't actually titled abuse of power. It didn't charge abuse of power. The specifications there were violations of law, violating the constitutional rights of citizens, violating the laws governing executive branch agencies, unlawful electronic surveillance using the CIA and others, specific violations of law. And clearly in the Clinton impeachment, President Clinton was impeached for perjury and obstruction of justice. Those are crimes. And while Professor Turley does not take the view that a crime is necessarily required, he pointed out here that there was not nearly a sufficient basis and not nearly a sufficient record compiled in the House of Representatives to justify an abuse of power charge. He also was very critical of the obstruction of Congress theory, and he pointed out that it would be an abuse of power by Congress under these circumstances, where Congress has simply demanded information, gotten a refusal from the executive branch based on constitutionally based prerogatives of the executive, a refusal to provide that information, then to simply go straight to impeachment without going through the accommodations process, without considering contempt, without going to the courts. That was Professor Turley's view of how incrementally the House of Representatives would have to proceed if they were going to try to reach, ultimately, some theory of obstruction of Congress. So to cite Professor Turley, it is true that in his academic writing and in his testimony, he did not adopt the view that you must have a crime and only a crime as the charge for an article of impeachment. he still thought that neither of the articles of impeachment here could be justified or were sufficient or could be used to impeach the president, both the abuse of power article and the obstruction article. So taking snippets out of what he said really does an injustice to the totality of his testimony, because the totality of his testimony was entirely against what the House ended up doing here. Thank you.